Hello and welcome to today's Libro Credit Union webinar, Estate Planning to Estate Doing. My name is Paul McQueen. I am the VP of Wealth at Libro Credit Union. And on behalf of our 700 plus colleagues at Libro, I'd certainly like to welcome you to today's webinar. My job title that I just shared there is not a favorite of mine, VP Wealth. I don't think explains what our coaches do very well on a daily basis. I actually prefer financial planning and investor behavior, which better reflects the work that we are doing with our owners each and every day. Couple sort of housekeeping items as we go through a couple slides here before we get started for today's presentation. If we could jump ahead one, please. Slight delay. I'm going to be joined today by Doug Carroll, our tax and estate specialist from Aviso Wealth, and I'll give you a brief bio on him momentarily. A little bit about Libro to get started. As I noted, we have over 700 employees at Libro, servicing 36 locations. We have over 110,000 owners who entrust their financial business to us each and every day, and we appreciate that trust, and we take that trust very seriously. Libro is a B Corporation certified organization that believes that we have a way to be good and do good with our business for the environment, for the communities that we serve, environmentally, socially, and in our governance models as well. And finally, just a couple things to note for today's seminar. This has been a very popular topic. We ran this session about 2 years ago now, and with one of our highest attended sessions at the time with lots and lots of questions. If you do have questions, we can't see or hear you. Really, the only way to get those questions would be through the Q&A function, which some of you have already started to use. We would note that general questions will work best if you have really specific questions about your personal situation. We'd love to talk to you about those, and our coaches are willing to help, but they may not always be the best for this kind of particular format. You can reach out to connect with one of our coaches at our website. A recording of today's session will be made available, as well as some handouts, probably as early as tomorrow. You'll see that in your email. So at this point, I'm going to turn it over to our guest speaker, Doug Carroll. Doug is the tax and estate specialist for Aviso Wealth. Aviso is our wealth partner, as they are for many credit unions across the country. For those of you who have investment business with us, you may be used to seeing statements from Credential Asset Management and/or Credential Securities. That's all part of the Aviso Wealth family. Doug previously ran an estate planning law practice, was an advanced case consultant with a life insurer and a mutual fund provider. He holds a business degree, a master's of law, specializing in tax, qualified as a certified financial planner professional, and as a trust and estate practitioner. Doug's been doing this for over 25 years now, supporting our financial advisors from written articles to individual case consultations, and of course, webcasts like the one we're doing today. Very excited to have him. Doug, thank you. I will turn it over to you.
Okay, thanks, Paul, and thanks again for inviting me to be here with you. I'm going to talk about this core topic, estate planning, which, as I generally introduce this, it is the first place that I'd spent my professional life. I was working in law practice, general law practice at first, but once I got established in my own law practice, I decided I would do a focus on estate planning, particularly with small business owners, but in combination with going and seeing people in their own homes. It was I was young and I was mobile, and so I decided I would set myself up in that way, and spend a lot of time sitting with people, evenings, having a cup of tea over the kitchen table with them, talking about their estate planning, or with the business owners, visiting with them in their businesses and talking about their estate planning related to their succession planning of their businesses. So this definitely is core type of knowledge and background for me. And to me, in terms of your financial lives, as Paul was mentioning about speaking with your coaches about your financial needs, I really do believe that your starting point for your financial planning is in large part your estate planning. So who are you going to take care of before what you're going to take care of for those whom you are going to care for? So that's my general view on where it sits in the priority sequence of the decisions that you're making, taking care of the people so that you can better focus your attention on the things that you have and the things that you acquire, and do your best for them. So with this, I'm going to take you through just a handful of topics. There will only be this number of slides that I'm bringing up. I don't think I brought in an extra one, so just total a half dozen slides, including this one, and then the 5 that follow from it, where I'll walk you through that, what I was just saying about taking that people perspective before you get into the substance, in that case, or in this case, the substance of the estate planning, and then walking through the estate planning process again, not the nitpicky little steps about it, but the nature of the estate planning process, and how it is to approach that in a way that can put you in a good position to have better conversations with the lawyer who you're going to engage to do that work with you. And I definitely definitely suggest that you work with a lawyer. The do-it-yourself approach is not necessarily a problem for all people, but it leaves a little bit too much to chance, in my opinion. And so working with a lawyer, and I'm not here to get employment for lawyers, but working with a lawyer for this very critical part of your life is quite important. It's not that kind of thing that you would do repeatedly over the course of time. And yes, there is cost involved with engaging a professional, an experienced professional, but it's one of those things that is definitely worth the time spent and the value that you get from having that kind of professional interaction. So I'll move from there to talk about the process that's involved with the paper, the different documents, the key documents that are involved with estate planning. And then from there, talk about ways that you can reduce the cost, reduce the administration activities possibly. So priority sequence is take care of the people and put things in place as a plan, then look to reduce down the costs that might be involved in putting the estate planning together, that then would lead to the estate administration, the actual activity of managing the estate. And then just a last couple of points about giving it a little bit of a light of fire underneath it to get you going with your estate planning. So I actually have a allergy related throat thing going on here, so I'll probably be sipping at this more often than I normally would here. Tea at this time of the day, cold tea. So I think it's really important that your perspective on your estate planning be on the people. And quite often when people use the phrase estate planning, it's focused on the documents or the time in your life or the point of a person's death. But really, estate planning has to be about the people who are connected to the estate planning. And when you talk about the people, depending on who you are, it might be that you are concerned about taking care of others, which is obviously what it's about. But it's also you as the center of your estate planning, you at the core of the estate planning, and taking care of yourself now and taking care of yourself in the future. And I use that as the standing way that I tend to refer to estate planning. I'll probably repeat it again here because I tend to just sort of fall into it. Estate planning is about taking care of yourself now and in the future, and taking care of the people around you now, in the future when you are around, and then further on in the future when you are not around. So when people talk about estate planning, sometimes they will equate it to having a will. And a will is a critically important document that I'll discuss in a little bit more detail a little later on. critically important document that deals with what is going to happen with the property that you own at the point of your death. So in my rundown of taking care of yourself now in the future and the people around you, now in your future and in the future when you're not around, the will really only deals with that last part formally of what is going to happen after you die. It's a critically important part of things, but it is a limited part of things. And the reason why I want you to start with you as the core of the estate planning is because estate planning is about taking care. And if you're not taking care of yourself, it's that usual analogy we use to, hey, when the plane hits turbulence and the air masks drop down, put your own mask on before you put the mask on of those other people who you might be taking care of. And that's true in estate planning as well. Too often my experience had been, not all the time, but it had been that I would be seeing people, as I say, in their homes, talking to people, seniors quite often, and seniors, in a lot of cases. When I say that, I mean people who, for either physical reasons, comfort level, they did not or could not get out to see a lawyer, and so that's why I would go and see people in their homes. And these would be people in a lot of cases who were concerned about making sure that the next generation after them was well taken care of. And sometimes the next generation was or were themselves already retired as the next generation beyond the people who I was speaking to. So I'm not suggesting here that you not care about and care for those other people. That is what estate planning is about. But that you start with making sure that you're taking care of yourself. There's definitely a connection between financial planning, making sure that you have enough for yourself, that you've planned your wealth to make sure that you're taken care of, and extending out and taking care of those other people. So start with yourself. And when we talk about estate planning, and again, I'll talk about the documents, that includes making sure that you've got the appropriate documents in place that should you be unable to make decisions on your own behalf, that you have thought through who are the appropriate people to assist you in making decisions about you and the things that you have. So I'll come around to that when I'm talking about the documentation and particularly about powers of attorney. So you're taking care of you now. You are taking care of yourself in the future by thinking through the needs that you will have at that time and putting safety net in place to make sure that you've got one or more people who will be able to make decisions on your behalf to take care of you out in the future if you're not able to do that yourself. And then as you move forward, as I say, while you are living your life with the people around you, look out forward and say to yourself, how am I taking care of myself with the people around me? And what I'm getting at there is, again, estate planning is sometimes equated with, oh, sorry, hit the screen there. Estate planning is sometimes equated just with the will taking effect. But if you focus solely on the will, you're missing the broader picture of the taking care of the people around you. And if you want to think about it in terms of tax efficiency or just enjoyment of life and enjoyment of the things that you have built up as property to help you in your life and help those other people around you, having the focus solely on the will, that things are going to transfer at the point of your death through your will, misses out the possibilities that might be available to you to share your property, not putting yourself in the poorhouse in the course of doing so, but share your property with the important people around you so that you can help them through their lives and enjoy the fact that they are enjoying the property that you've built up, and whether that is the use of that in terms of spending cash, or it is something which is an item that you own, your 57 Chevy, and you want to have your child be able to drive that just as you've driven that particular vehicle and have enjoyed it yourself. So that means that focusing solely on the will as the document and the event of your death is really truncating the estate planning thought process and the estate planning conversations you can have with your lawyer about the things that you can do to make this a really important and comfortable exercise, knowing that you are providing for those people around you in as broad a way as possible. And then again, when you're not around, certainly that is what we want to make sure that we've addressed is how it is that the property that we have is going to pass on to those other people, and who is going to be responsible for doing that, and that would be the executor of your estate. So that's our the broad view that I have. And then in terms of who the people are, we can talk about beneficiaries formally of your estate, which would be the named individuals who are appearing in your will as beneficiaries through your will. And we can also talk about things that might happen which are outside of the will. Again, the possibility that you focus your attention on ways to transfer your property without putting yourself in a difficult position by using other means, possibly using joint ownership of property, whether that's investment or checking accounts or other savings accounts, or it is real estate that you might join them onto so that they will carry on in the ownership of that property. Those types of actions are not things that will be governed by your will. You're actually skirting around your will by doing those things. And so the nature of beneficiaries, if you think about it as more of an expansive view beyond the formal beneficiaries inside of your will, then you can open up the possibilities of what you can do with your estate planning. The last item, well, not the last item, but the last item under the beneficiaries grouping here is being careful that if you do not address your estate planning, if you don't have a will at all, then you're going to have an intestacy, and then the provincial rules of intestacy will dictate who is going to receive the property and in what proportions and in what time, which might end up being a delay as a result of not having a will, because it takes a little bit more effort and time to deal with an estate that does not have a will. So you may end up with a proportionate distribution among the people you care about differently than you would have otherwise desired to have happened. You may end up that some people are not included that you would have wanted to include, because the rules of intestacy keep very tightly within the family structure, and it depends on whether you have spouse and children and how further out things go from there. Who gets some entitlement out of your estate and how much they get. You just don't have any control about it if you don't have a will in place. So that's one concern. Where you don't have a will, you lose that ability to state who and how you're going to distribute things out. The other thing is, if you're not careful about it, and again, not to completely point the finger at do-it-yourself wills, but if you have even a small amount of complication in the relationships that either you have with the people around you or they have with the people around them, the drafting of your will may not be adequate to protect against the possibility that others around those people who you're trying to directly care for may be able to access the inheritance that you intended for them and them alone. So making sure that the drafting of the will is done in such a way that it protects against possible distribution out to future ex-spouses where there's a breakdown in a relationship, or to creditors that might be able to get at that property if you have sufficient detail in the drafting of a will that you would commonly see where a lawyer drafts a will, then you'll be able to put in some reasonable level of protection. It's not going to be an occlusive seal that never can be broken through, but it's going to have more protections than otherwise would be the case if you're trying to do it yourself without knowing what the complications could be out there. And the last thing I've got here in terms of who are the people who are around you, the people who you name in special roles will be who is going to be the executor of your will. Executor means to execute the instructions in your will. That will be the person, one or more people, or it could be a corporate trustee. One or more of those people will become the owner of the property in order to carry out the instructions in your will. And they become the legal owner of the property to hold on to it, to distribute out to the beneficiaries of your estate as you lay that out. And that may be that you have everything distributed outright at the point of your death, or it could be that you have concerns because one or more of them have a disability, have a creditor concern, a matrimonial concern, as I mentioned, that there may be reasons to delay or restrict access to that property that is going to go to them by having a trustee continue for some period of time as the continuing legal owner of that property, so that it can be managed by a responsible individual as the trustee, and then eventually be transferred to the people who you ultimately are intending as the recipients of both the income off that property and then the property itself. And the final thing here is about guardianship. If you have minor children, then your will is your opportunity to name someone who you would like to be the new guardian of that person. If you've got a surviving parent, then the surviving parent would be the guardian. But if we don't have either of the parents there, then it's the last opportunity you have to make your statement as to who will be the guardian of your children, which then does have to be confirmed by a judge. But it tends to be that the judges will follow, unless there is something unusual involved, they will tend to follow the guidance of the parent, but always looking at what's in the best interests of the child. So that's the people process that we have. Then I want to the people focus. Then I want to turn here and talk about the estate planning process. We hear people saying that a person might say, "I have an estate plan," as a noun, an estate plan. And I don't, without being the grammar police, I don't like that kind of phrasing, because there really is no single definition of what is an estate plan. A lot of people think if I've got a will, whether it's done with a lawyer or is done as something that I did on my own, that constitutes, again, quotes around it, an estate plan. But there isn't something that you can look up and say, oh, an estate plan is this, and this, or it's one thing. There is no way of saying definitively this is an estate plan. I prefer to think of it in terms of being engaged in estate planning, as in the process you go through. Again, who are the important people around you? What is the property that you have that you can take care of yourself presently and on to the future? What will you have to take care of them out there further on? That's the kind of personal inquiry that you should be going through, thinking about you and your ability to take care of yourself and those around you, and then using the professional skills that are available to you through an experienced lawyer to be able to put in place the necessary components to carry that out. So a will on its own is, as I said with my my loan definition, take care of yourself now and in the future, taking care of your people around you now and the future, and when you're no longer there. The will is that last part in terms of its activation when you die, And the equation of a will equals to an estate plan, even if you're into that phrasing, it's just not sufficient. It needs to be much more than that. So just be careful about do it yourself, in that there are lots of things that you might do, as I was going through earlier, you might do that do not go through the will. And it's very difficult to know whether you've checked off all the boxes unless you're talking to someone who has done this before, who's seen how it is that it can be done, and has seen what happens when it's not done in a proper way. Sometimes people will say, well, having a will, a do-it-yourself will, is better than nothing. I would say that maybe that's true sometimes. In other cases, it may not be better than nothing. It's certainly better that you have a well-informed will that is well drafted than having nothing. I'll tell you just a little. There's a client situation that that I dealt with. Is actually a friend, and the father was in hospital near the end of his life. He had cancer for a while and spent about 2 months in hospital at the end of his life. It was quite a while ago, actually. And in the course of being there, he had done a do-it-yourself will. The friend of mine went to the financial institution to get the last assets, because he'd been in hospital for a couple of months, and most of the property had been moved over and were in the hands of his surviving wife. But there was one account which was remaining. It had a relatively small amount of money in it, and they were sitting there with the branch manager talking, and the branch manager was content, based on the situation, a long-standing relationship, to transfer it over to the surviving spouse in this case, right up to the point where my friend brought up the fact that the deceased fellow, had done a do-it-yourself will that reinforced the transfer over to his wife. And the problem was that he hadn't done one of these things while he was in hospital. He had done them almost every week, and he wrote them up differently each time, and they were executed differently each time, with all the best of intentions, that caused a lot of confusion and put the branch manager in a really difficult position, where she had to say, I'm going to have to get you to probate that now. So you're going to have to take that do-it-yourself will, and actually the number of them, to determine which one actually governs things. They were conflicting in small ways sufficiently that the branch manager wasn't comfortable with that. So is it better than nothing? Maybe, but just be very careful assuming that your decisions that you make, usually on a limited knowledge basis of the law, is not necessarily better than nothing in all circumstances. Now, if you're consulting professionals, and again, I strongly advocate for using lawyers. Again, not trying to be the lawyer's employment service here, but using lawyers who are experienced in estate matters, or using a lawyer who's experienced in estate matters. What I say is that you ideally are going to be able to access their skills in a way that the two of you meet in the middle. So the lawyer has experience in legal matters, and very specifically in estate-related legal matters, whereas you have experience in you. So when I say here, expert meet expert, you need to provide sufficient details about you, so the lawyer can take that broad expertise and apply it in your circumstance. So between the two of you, you are able then to fit things together so that you get the legal available ingredients applied in your situation, and it all hangs together. It all works together. The process that you're going through, don't think of it as purely production of documents, which is necessary to produce documents that are supporting what you're doing and that can be executed and depended upon. but that you are going through a consultation exercise. You're paying for it. You're going through this consultation exercise that involves discussing things, determining what things are in, what things are out, and then documenting it with those key documents, producing those documents to make sure that that they actually do what you want to do. And then the last thing here, I know I said that I felt the core of financial planning is estate planning, but truly it's a back and forth, give and take on that. If you are going to be able to take care of yourself and the people around you, you really do need to know where you're at financially, so that you can make the decisions that actually will be carried out. So starting point for your estate planning, even though I said it the other way, starting point for your estate planning is very much knowing where you're at financially. I say balance sheet to begin here. What I'm referring to is making sure you know what you have, what your sources of income are, any debts that you have, so that when you put your planning together and you intend to take care of spouse, your dependent children, your adult children as inheritances beyond that, that what you want to have happen in the transfer of the property to them will actually be able to be carried out in the way that you intend. And particularly if anyone is dependent upon you, you want to make sure that the financial components actually fit together so that you can be comfortable and confident that it will be carried out the way that you intend. Okay, so I'm going to move on from there and talk about the documents. As I said, sorry, my screen is flashing at me here. I'm going to move off the.
Well, I'm going to jump in, Doug, just because we do actually have a couple questions that have come up. There is a question about trusts, which we're gonna leave because I know that's coming up. You can actually see it on the slide now about, do you recommend using trusts in all estates? There's a couple specific questions about property, which I'm just going to hold off till a little bit later in the presentation. There's also a question about using the will to avoid probate, or what are the sort of common ways, pros, cons of the probate planning process. I know probate's on a future slide as well.
Yeah.
But really there was a question around the age of age. Is there an optimum age or stage of life to start this, to create a will and or an estate plan? Maybe a bit of a leading question, Your Honor, but I'll turn that one over to you.
Yeah. So I know that the common response to that, and I'm sure you would guess that the common response to that is, once you have responsibilities, once you have someone who's dependent upon you, whether it's spouse or children, that's the point at which you definitely should have a will. I say it's even sooner than that. I would say that that the point at which you look to execute a will is pretty much the point when you are legally able to execute a will, which is hitting the age of majority. So age 18 would be the point at which I would say that you should have a will, and related to that, having powers of attorney in place. Again, powers of attorney, which I'm going to talk about here in more detail, but powers of attorney are about taking care of you. And so once you hit the age of majority and you have the ability to make out a power of attorney and give someone the legal authority, then I would say that you should be doing that. The reason why I say with respect to the will, even if you don't have a ton of property, and you don't have even let's say you don't even have a spousal relationship or a primary relationship with someone, I would say that once you hit the point where you're able to make out a will, I believe that it's appropriate to do so. One of the worst situations you can have for a parent is where there is what's called a death out of order, which simply means that your child dies before you, and it's devastating, obviously, for a parent to have that happen. It's particularly devastating when it's a young child. And so if you are in a position where you hit the age of majority and you are able to make out a will, then it's not a financial matter to say, oh, I can save this much of probate tax or tax if I do this thing. What I can do is I can make things, I can put things in a sufficient structure where my parents will be able to take care of the administration of my totally unexpected, totally unlikely estate before their own departure from the world. I can put things in a position where I can make it easier for them to deal with that, to deal with the administration, so that they can grieve. And so that's why I say, once you are able to do so, I think that that you care for those important people around you, your parents in particular, if you take care of your estate planning at that early stage, and that you do the powers of attorney to take care of yourself. So if you're not going to go on to another question, Paul, I'll go into the documents now that I've got up here on the screen. And these are the core documents that are involved in your estate planning: the powers of attorney, the will, and potentially one or more trusts that you might put in place. And a trust can be established during your lifetime. It can be established as a component of your will. So the will is the document that speaks from the date of your death, which is probably for most people the more familiar of these documents, long-standing familiar document. Powers of attorney are documents that you can put in place where, and it's important to not that I'd be the grammar police, but to distinguish between a power of attorney, which is a document, versus the attorney, which is the person who is given the power under the document. So what the power of attorney does is it allows for someone to make decisions either about your property or about yourself. But in doing so, in you making out this power of attorney document, by executing it, you do not lose your own ability to make decisions about your own affairs. So that action of executing the document does not put you in a worse position. It puts you in a better position, as long as this is well thought out and you establish the power of attorney with someone named as the attorney, who is someone whom you trust. And when I say trust, because the word trust is on the screen here, I'm talking about trust in a generic sense of a confidence level that you have, that the person who you name will carry out the responsibility in a responsible manner, will do that in your best interest. So again, it distinguishes between the two types of powers of attorney. There are two different documents, in fact. There is the power of attorney for property, and there is the power of attorney for personal care. And even with the power of attorney for property, there is a distinction within that. You can make out a power of attorney which exists and gives someone authority to deal with your property for a limited period of time or limited scope of property. So long ago, I had a condo that I owned in British Columbia, and then I got a job back in Ontario, and my sister lived out in British Columbia. Because I was going to be far away, and it was well before we had the kind of digital engagement we have these days, I named her as my attorney to guide the rental of that property until I could sell it. For a few years, she was holding power of attorney over that. But it was only with respect to my condo in BC. It wasn't for all of my property. Whereas a general power of attorney is in anticipation that you may become incapacitated, incapable of dealing with your decision making, either because you are unconscious, if you had an accident that had occurred, that you're unconscious and cannot respond, or it could be in anticipation that you would go into declining mental capacity. Then you can, while you are capable, execute a power of attorney to give someone else the ability to make decisions about your property. And you can have that set up so that it will continue on past your own incapacity. So you may not be able to make decisions later on because you're in declining mental capability, but that person, if you have named them at a time when you were capable, will be able to continue making decisions about that property on your behalf. When I say property, sometimes people get this notion that property equates to real estate. Because when we say property, quite often we mean, quote, real property. Grammar police again. But property is anything that you can own, and actually distinguishes in law between property which is movable, which is personal property, and property which is fixed, which is real property or real estate. So a power of attorney for property deals with anything that you can own, and if you add in the phrasing into the document, which is common to do these days, that allows the person to act after you are incapable, then it's referred to as a continuing power of attorney. There are a couple other phrases that exist in other places, but in Ontario, continuing is the phrase that's used. They're also called enduring, and I can't recall what the other phrases might be. There's a couple of them, but continuing or enduring power of attorney for property, that's what it's referring to, is continuing on past your own incapacity. Then we have a power of attorney for personal care matters. That is about you. So power of attorney for property, that's about your stuff. Power of attorney for personal care is about you and how you are going to be taken care of if you can't respond and give instructions on your own behalf. It goes beyond medical decision making. Quite often people are thinking about, well, it's the do I accept a particular treatment, or am I giving consent to a particular process involved with mental health matters? But it goes beyond that. It has to do with where you're going to live, your nutrition, your social arrangements. So it's much broader than just the medical decision making. It gets into all of the things having to do with you. They are two different documents. You could name the same person to act as your attorney in both cases, but they are two different documents that give the respective type of power to the person you name. And I've been saying this in the singular as the person, but really you can name more than one person to act as your attorney. There is no limit on how many people you might name to act in that way. There's a practical limit to doing these kinds of things. And if you have multiple people involved, then best if you are clear that the priority, if there's an argument among them, is either this person's decision it trumps the others, or that there is a majority decision making that might be involved. There should be something that makes it clear how it is any differences of opinion are resolved. Otherwise, the intention that you have to make things more streamlined may turn a little bit more complicated if you don't have a clear statement in there about how they're going to interact with one another. Sometimes the phrasing that's used is legally, the phrasing that's used is you name them jointly, which means they have to do everything together, have to be in agreement on everything. The other common way to do it is to have it as joint and several. So the word joint, unfortunately, appears in both of those ways of setting this up. Under a joint and several arrangement, any one of the people you name can make decisions and bind the whoever is taking those decisions, can be binding in the instruction they give. And it doesn't require all of them to be in agreement necessarily, but where they are in disagreement and someone is taking instruction, and you have two different or three different instructions, then that definitely puts that person in a very difficult position, and you may end up, if things cannot be resolved at all, you may end up in a legal battle over whose opinion, legal opinion and legal instruction, will be followed. But that's the key distinction: is joint means all together. Joint and several means any one can act on behalf of you as the grantor of the power of attorney. So you're known as the grantor. Some places it's called the donor of the power of attorney, and you're naming the one or more people to then take care of your property and yourself in each of those two documents. Now, you think I'm going to go as long on the will and on the trust, but I'm not. The powers of attorney are a little bit more of the unusual. Most people have not come across in any great detail, but the will is certainly something that I think a lot of people have at least a notion of how wills operate. So a will speaks from the date of your death. It says who is going to get the things that you alone own in your name at the point of your death. So that's the purpose of a will. And if you don't have a will, as I mentioned earlier, then it's referred to as an intestacy, and the provincial rules will then distribute the property to people close to you, but not necessarily with the timing and in the proportions that you would have wanted to be the case. So it's not that your property is going to be given to someone who is far away and disconnected with you. It will still be those close to you by blood relationships, but there's not a lot of maneuverability involved. There's not. It will be according to what the terms say in the provincial rules of distribution on the intestacy. And then the last thing here is about trust. A trust is an arrangement where you name someone who will be a new legal owner of property to manage that property for a beneficiary who you've decided needs to have someone else as the trustee, as the legal owner, manage that property and make the decisions about it. So I look at it as a triangle. You're the original owner of property, and you're splitting out the ownership out to have a new legal owner here down at this bottom point of the triangle. And then over at the other point of the triangle, we've got the beneficiary who is going to receive the property, who is has the beneficial entitlement to the property, to the income off of that property. And with a trust that's created in your will is the document that creates the trust, and you say who is going to be the trustee, and it might be your executor of your estate continues to be the trustee for one or more beneficiaries, and then it's a relationship between them where the terms of the trust will state how long it is to continue in existence and whether there are further details of how it is that the trustee is supposed to manage the ownership of the property for the beneficiary. And
Doug,
then
I'm gonna jump in just one quick question on your previous slide before you get into this one, specifically around holographic wills. And for those on the call who may not be familiar with that expression, generally what we're talking about in a holographic will is a handwritten will that someone has signed and had witnessed by themselves. But just any general thoughts, any particular concerns or issues in Ontario in particular that an individual should be aware of?
Yeah, so a holographic will or holograph will is as you say, Paul, it's something which is in your own handwriting. What you really got to be conscious of is that a do-it-yourself fill-in-the-blank will, which may be less common now that we have the digital world than was the case when it was all paper and pen. When you do the fill in the blanks on one of those documents, if you don't fill it in properly, if you don't do the witnessing properly, then the handwritten parts of it may constitute a holograph will, because that part is in your own handwriting, but the typewritten parts are not included. That makes it really difficult to interpret. If you have something which is entirely in your own handwriting and is clear that it is your handwriting and when you made out the document, then that could be followed as a will, but it leaves things up to chance. In a desperate situation, it may be that that's the only thing that's left, like in a truly a life-threatening situation. But otherwise, it's much better if you're going to engage with a professional who can advise you on doing these things and make sure that you cross the T's, you've dotted the I's that are out there, so you don't end up being in a situation where you're not really sure whether this thing is going to carry out the way that you hoped it would carry out. I look at I know I'm going on and on about this, the do-it-yourself will concerns that I have. The fact is that all of your relationships, all of your property at one point in time, everything merges, and to have the treatment of all of these important people around you, and the distribution of property, which can be small or substantial, come down to a document that is not, or hasn't taken advantage of the expertise that could have been applied to it. It just creates a potential for disaster. And I do understand that there's cost involved with engaging professionals, but this is not something that you're doing on a constant basis. This is something where you'll go through this focused time, and I'll come to this as I'm wrapping up in just a little bit. You will come back and review these things, but it's not a constant thing. So keep it in context that all of your property that you've accumulated to the point of your death, and all of your relationships and the potential problems that could be caused if things are not managed in an appropriate way, merge at that point of your death, which for most people is an unknown when it's going to happen, totally unknown in a lot of cases, or at least not entirely known if you have a medical condition that you may be in decline, but you don't know exactly when things might come together. It's just really dangerous to me to rest upon a do-it-yourself, and particularly a handwritten do-it-yourself, which might be subject to interpretation. So, is it possible to do it? Yes. Is it a good idea? Generally, I would recommend against it if you can have a professional assist you with it. So I'm now on to this point, which is quite often the first thing that people bring up when wills or estate planning comes up. They say, "How can I avoid probate?" Like, okay, well, let's understand what probate is first before you start looking at trying to avoid it. In fact, let's make sure that you've taken care of yourself now in the future, and the people around you now in the future when you're no longer there. Then let's look at potentially reducing down costs. So probate is the process and the documentation and the probate tax. It's not actually called probate tax now, it's called the estate administration tax, but we use the term probate to refer to this in a generic way. Basically, when you have a will and a person dies, those who are not closely connected to that person, third parties, institutions that might have assets of that person, as the executor of the estate wants to take on the administration, they'll go in to see these others who have property belonging to the deceased person, and will look to take control of that property. The will is the document that gives the legal authority to the named executor to do that. The problem is that those third parties, those holders of the property of the deceased person, they don't know if the document might be a forgery, if it maybe was superseded by a later document, if maybe the person hasn't even died but is just out of the country and this is a scam that's going on. There might be all sorts of reasons. And so what tends to happen is, particularly with substantial assets involved, the request is made to, quote, probate the will, which means that the executor will go through the court process, filling out the documents of all the details involved with who this person is, and submit the will to the court. And as long as the court is content that in fact this is the last will of this person, then the court will issue back a certificate confirming that the named executor can operate under that will. And that used to be called a probated will. I guess you can still call it a probated will, but again, it's a certificate now, a certificate of appointment of the executor to operate under the will. And executor is not the formal term anymore. It's the estate trustee. So executor means to execute the instructions in the will. It is an estate, and the person who is in that role is a trustee over the estate and the property. So it's referred to formally as the estate trustee. The probate tax is at its maximum is 1.5%. So there's no probate tax on the first $150,000 in an estate in Ontario, but beyond that, it is 0.5% that applies on the value of the property, but it's never more than 0.5%. So on $1 million, leaving aside that first bit, on $1 million, it's going to be or 0.15%. So on $1 million, it's going to be $15,000 of probate tax. So proportionately, it's never going to be any more than that. So to plan on the basis of trying to avoid this relatively small tax is not the priority sequence of things. As I said, take care of the people that you want to take care of, and then look to reduce down the probate tax. And so as much as we don't want to pay any more tax or probate tax specifically than is necessary, just make sure that you don't throw out the baby with the bathwater in trying to avoid probate tax. There are some standard ways that you can avoid the probate tax without there being any serious concerns for most people's estates. Designate beneficiaries on your insurance if you have life insurance, and any other types of insurance where you can name a beneficiary. Designate beneficiaries on your registered plans, RRSP, pensions, RIFs, tax-free savings accounts. You can name beneficiaries off of those things. So those things will then go directly to the person you name as beneficiary. You also have the possibility of using joint ownership of real estate or investment accounts or financial accounts, where the surviving joint owner is the continuing owner of that property, the real estate or the investment account, when one of the joint owners dies. That's common to do, certainly between spouses. As you get past spouses, to add on a non-spouse in a joint ownership arrangement, you could trigger taxes that you didn't intend. You could expose that person's creditors. You could otherwise expose the possibility of a redistribution of your estate in a way that you didn't really intend. So make sure that you get tax advice and legal advice before you add on a non-spouse on joint ownership. And then the other thing is, you could just give things away during your lifetime. Again, without giving away an amount that puts you in the poorhouse, you could give things away, and then that will belong to those people. Now you don't own it at the point of your death, and therefore it's not subject to your will. It's not subject to the probate process or the probate tax. And then there's some other things that can be done in more where you have things a little bit more complicated. You could set up a secondary will, and it's something that's sometimes done where people own a small business, where you would have two wills that would, one would deal with your property generally, the other one would be select property, like the shares in your business corporation that you're going to have go through the secondary will, that allows that to be more confidential, because your will could become a publicly known document if someone was able to get into the court files and look at that and see who's getting the distribution of your property. It also can be a way, by having a secondary will, to avoid the probate tax on what might be your largest asset, your business ownership. You can set up trusts during your lifetime, what are called alter ego or joint partner trusts, if you're over age 65. Instead of having everything go through your will, you can transfer some of your property, and generally you'd have to have pretty substantial amount of property to be doing something like this. And you transfer some of your property into that trust, where instead of having that property fall into your estate at the point of your death, it instead goes over to your surviving spouse, if you have one, or if it's just you that's left over, it then goes over to other contingent beneficiaries. It does not go through your will. It doesn't go through the probate process. You can also do things where you set up corporations if you have really substantial investment assets, and pull your debts in there, consolidate things. You're generally going to have an accountant on speed dial if that's you looking at doing something like this. And then be aware that your Ontario will, well, the will where you live, your Ontario will does not directly deal with real estate outside the province. Outside the province, your will govern what is going to happen with that property, but the will likely will have to be reproven or certified in that other jurisdiction to deal with the real estate in that other jurisdiction, whether it's another province or another country. So sometimes what people will do is set up both wills and powers of attorney in that other location. So if you spend a lot of time in Bermuda and you have property because you're from Bermuda originally, then it's not a bad idea to have a Bermuda will and powers of attorney specific to Bermuda, but then you have your core documents here in Ontario that deals with everything else. So I know that's a lot to throw at you, all these possible things that are going on. Bottom line on the whole thing. Probate is unfortunate, but be careful not to plan about this tiny little tax and let that little tail wag the whole dog of your estate planning. So I'm just going to wrap it up here. We're almost on the time here. I'm just going to wrap it up, and I'm not going to deal with this in great detail anyway. To get things going, really important that you think this through about taking care of the people around you. Recording information about yourself and your wishes, and there is a document that we can make available to you, which is to fill in information about the things you have, so that you can know what you're working with as you go and have the conversation beginning with your lawyer about what you're going to do. In terms of communicating, you're under no legal obligation to tell the people around you that you're involved in your estate planning, but practically, it's good to have an idea of what their expectations are, because if you're going to name one of them, your children, adult child, as an executor, and they don't really want to do it, you don't want to have that found out after you've passed away. So communicating with them is helpful to get their input, to prepare things in the appropriate way and to make adjustments. And the last thing here is, as I was saying earlier, making changes and what kind of things prompt you in terms of making changes. You're not making out your wills and your powers of attorney over and over and over again, but there's three things that might prompt you. The passage of time, changes in your property, or changes with the people in your life. So in terms of the passage of time, my suggestion is you'll probably look at reviewing things, but not necessarily changing, about every 5 years. So check back to the lawyer's office, because there might have been a change in the law, because there's been elections and another party has come in, either federally or provincially, that might affect you. There might have been a ruling at a court level based on assets, property, or relationships similar to your situation. So about every 5 years is sufficient, in my opinion. The second thing is, if the property itself changes, then that would change how is you going to distribute things. And the final thing is the most important. If there are changes in the people, someone dies, there's a birth, somebody gets married, somebody gets separated, all things having to do with the people, then that might be a good reason, again, to give a call to the lawyer's office and say, hey, should we be making changes? I know I'm actually over time, Paul. So I'm going to shoot it back to you and see if there's anything else that we're going to touch on here.
Well, yeah, no, and I appreciate that. I genuinely appreciate your passion for this subject, Doug. There certainly are some questions here. We're past our 5 o'clock cutoff time. I'm able to stay for a few more minutes if you are, but recognize that some of our attendees may drop off. So a reminder that the call will be recorded and a replay will be available. So if it's okay with you, Doug, we'll go through a few questions. Try to be relatively quick. And if you can't stay, hopefully you can catch the replay on the other end. So there was one clarifying question around probate or the estate administration tax in Ontario. I believe you said it was voided on the first 150,000. I believe that's actually at 50,000.
It's 50. Sorry.
Yeah.
The
Under 150, you can go a simpler process for actually getting it done with the lawyer.
Yeah.
So I knew what you were getting
at.
Yeah.
After I said that, I thought, did I say 50 or 150?
Yeah,
Thank you.
No problem. So first 50,000. But again, I think your larger point is, don't take unnecessary steps to avoid probate. Let's take the straightforward steps to avoid probate where we can, designating beneficiaries, etc. And we'll deal with the more complex cases as they come up. There was some questions around property and RSPs, a relatively simple one. If your RSP beneficiary is your child, then where is the tax collected?
Tax is on the deceased person's estate. There can be rollover of registered money to a spouse, so you defer off and it later will be taxed to the spouse. If you have a minor child, then it can roll over to the minor child, which is not usually the best situation anyway, even though it rolls over. When I say rollover, it's not tax the deceased. It rolls over in its full amount over to the child, but then it has to be paid out between the child's age and age 18, and so that wouldn't be the best of situations for most people. If it's a substantial amount of registered money, it's probably just as well that the tax is paid at the parent level, and as unfortunate and larger as that may be, it keeps the control of the money in the will and likely a trust for that minor child.
A question about should a couple, well, let's assume that's spouses from a CRA perspective, lots of definitions of couple obviously, have all their financial assets held jointly. We have some joint as well as some individual to account for the various deposit insurance coverages that are available through financial institutions.
Yeah. That's going to take care of a bulk of the estate, so that those things will not then flow through the ones that are joint will go to the other. But then on the second death of the two, then the rest would go through the second estate in that situation. Sometimes what people say is, well, what if everything's joint between us and I've got beneficiary designations on everything? Do I still need a will? And I'd say, yeah, you always need that safety net of having a will. There's going to be something. It's not the kind of thing where you want to be doing the bargain basement economy of not doing it. Do it, and after the fact, you're not going to be around to deal with the fallout if you didn't do it. So just make sure you've got a will in place.
Yeah, and just from personal experience, when you're opening a joint account with someone, let's really understand that it's a joint account. Everybody owns it. Question about some property. Any strategy to minimize tax upon death for a capital gain property? I assume we're talking about real estate primarily here.
Yeah.
We can roll over from spouse to spouse, but then what happens to children? Is there anything you can do on a home to reduce that tax obligation?
Yeah, and then that's a really complicated. It can go in a whole bunch of different directions. That would be the place where I would say be really careful about that. It's if you're talking about principal residence of the people who live and own that house, live in and own the house, then there won't be a capital gain on that property at the point of that person's death. If you've added others on who don't live in that property, particularly if it's a non-spouse, then you run the risk that the principal residence exemption will only apply to the portion of the ownership that is yours. And now the greatest benefit that one of the largest benefits we get from the tax system of the principal residence exemption, you just gave it back because you added your child onto that because they don't live in that property. So again, talk to a lawyer before you do that transfer about the tax implications. And if it's more complicated, they'll probably say, talk to the accountant down the hall about this, and we'll see if we can try to reduce it. But just be very careful about those kind of sledgehammer approaches like joint ownership to deal with smaller issues of probate tax and smaller taxes, income taxes.
And we've also, at Libra had a lot of experience with, when you run into situations of second marriages, commingled families, all these kinds of stuff, children from multiple different relationships, et cetera, et cetera. Just the importance of the will to really make sure that you've got extreme clarity on what your wishes are, what you want to happen, how you want it to happen, et cetera, et cetera. Those are the times where you've pretty much got to speak to a lawyer and work those kind of things out. Couple other ones in here. USA property. I think you talked about Bermuda and having sort of a specific will. Would the same sort of rules apply there, or any distinct tax considerations for US property?
I would say I just picked out Bermuda out of the air, but I would say with the U.S. property, to be really careful about with U.S. property. If you have, as a deceased person, if you have over $60,000 in assets at the point of your death, then a U.S. estate return has to be filed. So if you're intending to liquidate this thing and give away the value to your kids later on anyway, and they're not going to be living at whatever this place is, then if you can deal with it during the course of your lifetime, you're going to save a lot of trouble with doing extra tax returns. And yeah, so there is more involved with US. They have very stringent tax rules beyond most other places. So the general rule applies, and it's just emphasized where you've got US property specifically.
Okay. I've still got a couple more here, and I know we'll keep going, so I'm gonna impose on your generosity unless you've got another obligation.
I'm
Doug.
fine.
The next two should probably be relatively quick, and then the last one. So I've got 3 questions here, though. Unfortunately, just in the interest of time, if we get any more after that, I'm going to have to refer them to our coaches. But who's responsible for credit card debt on death?
The deceased. So you, if you're the executor, you're not responsible for that credit card debt. It's the deceased's assets that are there to deal with the with any debt of the deceased person. I'm assuming that that's not a joint credit card here. It's just that person's credit card. That said, if you are the executor and you begin managing that estate, and it turns out, this is actually a client situation I had where it was credit card debt, which was $200,000, and this is a long time ago actually, and a house that was $100,000. The person began administering the estate and then was forced to continue administering the estate by the creditor, who would not let the person, the daughter, stop administering the estate originally. Eventually they relented. But if you start administering the estate, then you are generally obligated to continue on. So one of the first things to do as executor when you're about to take it on is to inquire, look at it, and if the estate is insolvent, then you might just step back and tell the credit card company, hey, you own a house now, rather than getting yourself in the middle of it.
Speaking of more complicated situations, can a will override a prenuptial agreement if the will is made after or later than the prenuptial agreement? I guess that's probably an it depends question I'm going to go with.
Yeah, it depends. I would say, one, I don't know. It depends on the circumstance, and apart from that, I would doubt it. That would for you to have an agreement between two informed properties or informed parties with equal standing, so you don't have uneven negotiation. For one of those people to unilaterally, after the fact, try to revoke this agreement in some way, I think that'd be a pretty unlikely thing to happen. But as you can expect, intended or purported prenuptial agreements are ripe for litigation because, well, people obviously aren't getting along if they're fighting about those things. So, and it's emotionally driven too, so it can be
Absolutely.
totally irrational. Even if you are legally correct, you may find yourself in a battle, and it's just, yeah, it's one of those things that can cause a lot of problems.
That's probably talk to a lawyer and get good, strong legal advice on that activity. And the last question, this is certainly applicable to many owners at Libro. We're very proud of our commitment to agriculture in Southern Ontario. We're proud to work with a lot of farmers and agricultural related businesses in Southern Ontario. Farms do have some special treatment when it comes to capital gain exemptions and other things, but the kids want to keep our small farm. Any comments on that? Well, I'm going to make a comment that this is where planning really comes into play, but maybe from an estate planning perspective. Any thoughts to close this out for us today, Doug?
Yeah, I would address it yourself well ahead of time, and look at it practically about whether it's actually possible to carry on. I don't think there's anything really special from a legal standpoint about that, just based on the limited points that are raised there, other than that that it is something that is emotionally connected. Obviously, it's where they grew up. They want to hold on to it, but look at it on a practical basis. And if it's just going to be more headaches for them, then just be very careful about acceding to the children's desire, so you don't create waves and then allowing indirectly there to be a lot more tension later on when you're not around to try to help out with the fallout from that.
Well, excellent. Doug, I know you have to maybe put your disclaimer slide up real quickly, but on that note, I certainly want to thank everyone who joined our webinar today. Some great questions, some good discussion, lots of detail here, obviously, that Doug goes into. If you do have any specific questions that you'd like to follow up, please feel free to respond to the email that you will receive from our marketing team at Libro, and or please feel free to reach out to one of our coaches at Libro or contact us to set up one of those conversations. Thank you for allowing us and indulging us to going a little bit over time this evening, and we hope you enjoy the rest of your day. Thanks, Doug. Thanks, everybody. Have a great night.
Thanks, Paul.